Thank you. Is that better? All right. In addition to myself, the other members of our commission are, to my far right, Greg Pappas from Montgomery. To my immediate right, David Pruitt from Birmingham. To my immediate left, George Pierce from Vestavia Hills. And to my far left, Judge Carol Smitherman from Birmingham. Our procedure today will be as follows. We will have 2 advisory opinions to consider, FCPA civil appeals, and other matters on the agenda that we will take up in new business. We will hear complaints in the executive session for 2 reasons. 1, because will discuss the good name and character of certain individuals, and 2, because complaints, evidence, and witnesses and testimony before the commission are covered under the provisions of the Grand Jury Secrecy Act. We will return to open session to vote. If anyone present would like to be heard today concerning any matter that's on our agenda, please sign in at the table in the center of the room, and we request that all cell phones be turned off during the open session. And at this time, I recognize Pastor Clint Landry, who will give us the invocation.
Let me pray. Heavenly Father, we thank you today that you're a God who is interested in justice, in fairness, in things being right according to your character. Lord, for my leaders here in the state of Alabama, God, I pray that you would give them wisdom beyond their human capacity to know and do your will. Father, we look to these men and women as your stewards of truth. God, we ask you now to let every judgment, every decision they make be bathed in your righteousness. Lord, thank you so much. In Jesus' name, amen.
Amen. Thank you, Pastor Landry. At this time, we will consider our old business items. Each of the commissioners has had an opportunity to review the minutes from our June 3rd meeting. I have a motion to approve the June 3rd, 2026 minutes.
So moved.
Second.
All in favor, aye.
Aye.
Any opposed, nay. Minutes are approved. This time we have 2 advisory opinions for consideration, and I will call on the commission staff to present the new advisory opinions.
Yes. The first request we have for you all today comes from Daniel White. He is the Deputy Director of the Jefferson County Commission Environmental Services Department, and he is also a member of the Board of Directors of the Blount County Water Authority. In both of these positions, he regulates various private businesses, including engineering firms and construction firms. He has a daughter who resides in his home, who is a full-time civil engineering student, and who is interested in summer, school year, and future permanent positions with local engineering and construction firms. And he is seeking to know whether she's permitted to work for such organizations and the parameters that would be required of her or of him. Since she currently resides with him, she is his family member for the purposes of the Ethics Act for both of his public positions. Whenever that's no longer the case and she's not receiving 50% or more of his support or of her support from him, then she would not be considered his family member for the purposes of his public employee position with the Jefferson County, but she would still remain a family member of him for his position on the Water Authority Board. The Ethics Act in 3625-9A says that unless expressly provided otherwise by law, no person shall serve as a member or employee of a state, county, or municipal regulatory body or commission or other body that regulates any business with which he is associated. However, in advisory opinion number 2006-05, the commission rejected the argument that this section of the statute contains a strict prohibition that an individual may not be hired or maintain their employment with a regulating entity when they have a family member who is employed by a regulating entity. Rather, the commission determined that the underlying issue was whether a conflict exists that cannot be resolved. And the commission stated that while it is clearly an unavoidable conflict of interest for an individual to regulate himself or herself, a person who has a family member employed by a regulated entity may simply be removed from the transaction between the regulator and the regulated, thereby resolving the conflict of interest and averting a violation of the law. So here, 3625-9A would not prohibit Mr. White from continuing to serve as the Deputy Director of the Jefferson County Environmental Services. This position again. The JCESD, or a member of the board of the Blount County Water Authority, should Ms. White become employed by a business that regulated by his public positions. However, he's going to have to stay out and recuse himself from any involvement in either of these positions.
Any questions or discussion? Okay, do I have a motion to approve the advisory opinion? Okay, all in favor, aye. Any opposed, nay.
Mr. Chair, who was the second?
Mr. Pierce.
Okay, thanks.
Okay. The next request we have comes from Antoine Dunklin, who is a producer licensing director for the Alabama Department of Insurance. He plans to retire in 2027, and following his retirement, he wishes to establish a private consulting practice to provide insurance licensing, compliance management, and strategic planning advisement to insurance companies, agencies, and regulatory bodies. He states that these consulting services will not involve any judicial proceedings, contracts, which he personally substantially participated while he was in state services. He states that his business would not be able to avoid interacting with the Department of Insurance, but he would personally be able to by having his employees interact with them instead. And he is also seeking to make himself available as a sole source to the Department of Insurance. And in that position, he would be advising the Department of Insurance on disaster relief, emergency adjuster deployment, AI-based integration and training, consult on exams and exam site locations, and address producer licensing needs. So he's asking two questions of us. The first is whether he could establish a private consulting practice to provide services to these entities after he retires from his public position, and whether he could enter into such a contract with the Department of Insurance to provide consulting services directly to them. The revolving door in Alcode section 36-25-13C says that no public employee shall serve for a fee as a lobbyist or otherwise represent clients, including their employer, before their former department within 2 years of leaving that position. So here, Mr. Dunklin cannot represent clients before the Department of Insurance until that 2 years has expired, provided he's able to avoid personally interacting with them. This section of the statute does not prohibit his business from doing so, as long as he has employees doing it and he's not directly interacting with the department. There's also section D in the revolving door that prohibits public officials and directors from entering into contracts, grants, or awards with their former entity within 2 years. However, in Advisory Opinion 2019-11, the Ethics Commission recognized that the 2-year revolving door waiting period under subsection D does not apply to agencies who rehire former employees or contract with former employees or officials to provide personal or professional services on behalf of that entity. Also, in Advisory Opinion 2025-05, we held that the former mayor of the city of Opelika could provide consulting services to the city of Opelika as those services constituted personal or professional services on behalf of the city. And similarly here, the services that Mr. Dunklin would like to provide, this opinion would find would constitute personal or professional services provided on behalf of the Department of Insurance. And if you have any questions or anything.
I have a question. So, is this person, he wants to establish a business?
Is your
Can you turn your mic on?
microphone? Sorry.
All right, thanks. So, this individual wants to establish a business so that he can do work for this agency?
So
Or-
he's asking two possibilities. One is he would like to interact with or provide consulting services to private businesses or regulatory bodies that aren't the Department of Insurance. And then he's also asking if instead of that, if he could provide consulting services to the Department of Insurance, the specific services, those services would be what's on behalf.
Okay, and so on the first request then, is he asking if he can represent, his business can represent contractors that then deal directly with the agency, or is it other agencies that he's asking about?
So he's asking about other agencies, but there is the potential for his business to have to interact with the Department of Insurance on behalf of these clients. But in those circumstances, he would have other employees so that he's not personally representing these clients before his former agency.
So you're saying the way the law works is he can form a company and have one employee, and then
Right.
that employee can have the interactions?
Yeah. He just, the restriction is personally to him. It's not to his business or his employees.
Okay, thank you.
Can he provide advisory to that employee who's representing his company?
Yeah, the restriction is on his interacting, his representing before the insurance, the Department of Insurance. And so his employee could be doing that representation because 13 doesn't apply to him. It applies to the former public employee.
As we look at this, who monitors that person's activities to make sure that they adhere to the guidelines of what he can and can't do?
There's no
What's the mechanism?
there's no specific monitoring. We rely on people to file complaints with us for violations of the Ethics Act. So he's doing the right thing by coming to us for guidance beforehand, rather than us having to go in after a complaint is filed, because he is interacting with his former
And also to remember that government agency heads have an obligation to report violations of the act to us. So if anybody at the department is aware of that, they're under an obligation to report to us too. So I guess in that respect, not
Yeah.
only is the employer responsible for monitoring his own conduct, but those who supervise him are responsible for that as well under the code.
So he should be able to say, I didn't know.
Yeah.
Yeah, he's been advised.
Right.
Person's been advised, okay.
And I think a lot of agencies also, at least in the state, have outgoing employees sign a recognition of this revolving door restriction.
Okay.
I can't say it's all of them, but I do know that some certainly require it.
Are we able to provide some direction on just how involved, if at all, he can be between his employee that's interacting with the agency, and kind of what he's doing behind the scenes with that employee?
Sure. So the behind the scenes is not really the problem that 13 is addressing. It's really the direct representation, the direct interaction. Now, behind the scenes, I don't think it would come up here, but like, for example, we have engineers who like sign off on plans. They can't submit that submission to it because they're still representing by that signature. But as far as like helping on projects or anything, as long as there's somebody else who's actually doing the interaction, the representation, then the revolving door is not being violated. But they can certainly assist on other projects or give guidance to his employee.
So let me get this straight. The employee,
Oh, can you turn your mic on?
It's on.
I'm sorry. The employee can solicit business, but the owner, the retired person
Yes.
cannot.
The employee is able to interact with the department on
Right.
behalf of that business and their clients. It's the former employee who's not able to.
I don't see much difference. And, there's a thin line there.
Yes, ma'am.
And if I can interject, the historical guidance from the commission has always been about this representation is that they can do work in the background on projects. And I think, and I'm not speaking for the legislature, but the intent is that you cannot trade on the relationships that you've created within the department after you've left. And so this eliminates that relationship, even if they know that that person's in the background in the company, that direct interaction isn't happening. For instance, this happens frequently with people who work for, say, ALDOT. and they leave and they want to go work for Volkert. Well, Aldott wants them to work for Volkert because they're experienced and they know how to build roads, and then Volkert wants them to work for them because they have experience building roads. The issue is they just can't interact with Aldott, but they can work in the background with Volkert on these projects. They just can't be leveraging their relationships that they had while they were at Aldott after they've left.
What is in the background mean?
In the background, it means that they just can't have, just what Brian said, they just can't have direct communication with anybody in their previous agency. They can do whatever they want to at the office. They just can't have that direct interaction with anybody in the agency.
And just to reiterate, for y'all's sake, these are the proposed advisory opinions were based on previous advisory opinions, but if y'all don't like this interpretation and want to change it, we're happy to continue anything to the next meeting, work on another draft or 2 different drafts, and have further discussions then, if y'all have an issue with this interpretation.
But to put your minds at ease, if there is any, is that these advisory opinions are based on, years, decades of other advisory opinions and the sort of the historical interpretation of the statute. But as Brian said, if there's anything that you have a problem with, we can certainly retool.
David just advised me that I don't have a microphone. I guess you're telling me something. So I'll take that as a hint, but I have 2 questions. One, let's say example, a city hires a former Aldott employee to become their city engineer. You're saying there's restricted, if they're doing road building in a particular city, what that engineer can do as far as working with Aldott, is that correct?
No, so not in that circumstance.
Okay.
We have another advisory opinion, actually it's 2019-11, which is cited here. That revolving door restrictions are applying to private businesses, and private businesses are not businesses with which someone is
Okay.
associated for purposes of the Ethics Act, so it doesn't restrict public-to-public representation.
You said that wrong. He said that backwards, but public agencies are not considered businesses with which you are associated.
Okay.
So that there's case law that says that, Lambert v. Wilcox, that a university is not a business as that term is defined in the Ethics Act. And so you can go, like Hugh Evans left here and went to the Secretary of State. He was allowed to represent the Secretary of State's office before the commission because that was a public-to-public interaction, did not have private interests.
It's a plus for a city looking for a civil engineer, ideally someone who's worked for Aldott and knows how to work things.
Absolutely.
Knows the system in a sense.
Yeah.
Another thought is, as we approach with going through an election year, we're going to be going through changes coming up after the first of the year. You may very well have people leaving departments, join other places. What's the program to make sure that these employees are aware of the revolving door system? Because they're going to be under demand as they might roll off a particular area they're working in now.
All I can say is we provide training as much as we possibly can. To all elected officials have to receive training, certain employees, especially anybody who has to file a statement of economic interest. So there's several categories that apply. They're all required to receive training in the Ethics Act then, and we certainly cover revolving door and most, if not all, of those trainings.
Yeah, and also the agency heads are pretty up to speed on the revolving door. And in fact, most agencies interpret it a lot more narrowly than we have. So it's very common for employees to say, my supervisor's telling me that I can't do this for 2 years. Is that correct? And I think it's kind of out there.
Good.
Yeah.
But as
Okay.
Brian said, every time we train, every time I train, at least I specifically say, when you want to leave and you know even a year out that you're going to leave, start asking us questions. And they're real good. Ones who ask are real good about that.
Yeah,
Yeah,
I actually make
I'll-
sure to tell people to wake your neighbor up in this section. If somebody's sleeping, wake them up and make sure they pay attention to the revolving door, because this is the thing that will get you in trouble. Not to say that people sleep during my training.
Here again, it's a matter of, hearing communication is so important. Whether it's dealing with people running for elections and campaigns and finance, in this case revolving doors, is the opportunities are there. Just ask and you shall receive.
Yeah.
Don't ask and you may receive in the wrong way.
That's right.
But take advantage of the opportunities. The people are there, the source is there to get advisory.
Yeah, and I will say that probably by far the most common informal requests that we get are revolving door issues. We answer several of them every week.
Good, good.
So we're certainly giving advice as much as we can on specific instances for individuals.
Great.
Those were good questions. Those were good questions.
Thank you.
The,
Can I borrow your microphone then?
Maybe. So is the revolving door on the website?
I'm not sure if the revolving door section of the statute is specifically on the website, but we do have I believe we have a link to the code, which has the revolving door in it.
I believe the revolving door is in the FAQ.
It should be.
Yes, ma'am.
I have a question as a follow-up to Judge Smitherman's question. To me, I see a distinction in a situation where a government employee goes to work for a large company that has, hundreds of employees and the situation of the ALDOT scenario versus a situation where an employee leaves, forms a business, has one employee, then tells that employee to go solicit work. And I'm looking at the statute, and it says that the employee shall not enter into, solicit, or negotiate a contract, et cetera. And I think we should make it clear that if we're going to provide this opinion, we should make it clear that that doesn't mean that the employee can circumvent that rule by hiring an employee and then directing that employee to go do exactly what he can't do.
Sure.
I think there's just a distinction between the ALDOT scenario and what I'm describing. I don't know if this employee falls into either, but I would kind of like to make it clear that we're not condoning somebody, kind of getting around what the statute says.
Absolutely. So are you seeking to move this to October so we can adjust this opinion?
I would appreciate that.
Yeah.
Okay.
Once you make a motion.
Yeah, I'd move that we continue consideration of this opinion to the next meeting. Thank you, Brian.
Thank you.
AO 2026-11, is that right?
I'll second that.
All in favor, aye.
Aye.
Any opposed, nay. Okay, so we push back till the next meeting. Okay, at this time, the commission will consider appeals from civil penalties which the Secretary of State's office has imposed. Under the FCPA, the Secretary of State's office is charged with assessing civil penalties against any person who fails to timely file their campaign reports. Once that office imposes these penalties, they may be appealed to this commission within 14 days. Upon a finding of good cause, the commission may reduce or set aside the civil penalty. On this issue, the person upon whom a civil penalty has been imposed bears the burden of proof. I will again call on the staff to present these appeals for our consideration.
Thank you all. The first appeal that we have for your consideration comes from Mr. Raymond Cortez Hall. He is appealing 10 penalties with a total of $1,043.22. The Secretary of State's office's recommendation, since there are 10 penalties, would be to uphold the first 2 fines and offenses. So that would reduce the total of the penalty to $333.22. And I believe Mr. Hall is here today and has spoken with the Secretary of State's office, and he's fine with that recommendation. But Mr. Jones has anything to add?
Good morning. And this is an example of the volume of violations. Generally, if we have 4 violations or greater, we make a recommendation of accepting 1 violation. And pretty much as they increment up, we 4 more, we would add a second. And that's what we did in this. I actually spoke with Mr. Hall briefly before we started and explained that we're not a gotcha office. We're not trying to have him pay all these fines. But we also have to honor the intent of the code, and that we were only going to recommend 2 violations be accepted, and that it is our recommendation to dismiss the other 8. And I've spoken with Mr. Hall. I've also spoken with his wife and the person who does his work, and they're going to contact our office to know how to handle this part as well. So this is not, they don't have any mistakes on this as well. So we're going to work with them on that, so it should work out.
What is he alleged to have done?
Yes, ma'am. There's 10 violations. So the violations are the reporting periods. They're in the FCPA calendar.
Yeah, it's there's one monthly report and then weekly reports. It looks like there was 4 weekly reports that were missed, and then some more weekly reports during of the runoff and another monthly report.
That's pretty much what we do as far as the FCPA side. That's pretty much our concentration. Yes, ma'am. Yes, ma'am.
Because of lack of understanding, or just missing a date, lack of understanding, or?
I think on this one, I think many times it is a mistake, and that's what it turns into. We try to work with them. Based on our last conversations, I actually went through our webpage and made copies of everything we do to try to educate, instruct, give information. But it's a lot, and so, you know, frankly, if we were to add too much more, I think it would be overwhelming that we give that much information. One of the things we do emphasize is we give the phone number contact for our analyst and for our elections division on virtually everything, and we do that for obvious reasons. If we can get everybody to call us before they make those mistakes, then our people will walk them through it as best we can. But once again, our goal is not to be catching people. Our goal is to educate and instruct and try to make sure they don't have to come before this commission or don't have to file any appeals. And in many, many cases, in fact, I'd say the vast majority of the cases, when there are violations and we don't see intent, we actually recommend they file their appeals. And so that's how far we take it. And we tell your staff the same thing. So it's our goal to work with people. It's always our goal. One of the things I mentioned to Mr. Hall, and I'll mention to this because I think we had a previous conversation about this, is that there are some counties and some cities that when they start their election cycle, they actually do offer some class and some educational information. We do provide a lot of materials, including an Alabama candidate filing guide. We have these produced and we send these out to all the counties. We also, if requested by any of the cities, we have those made available. We do everything we can to give them materials to give to people who are running, to candidates, especially first-time candidates. And so we want to give them as much as we can so that they have a starting point. But you know, at the end of the day, once you decide you're going to be a candidate, there does come a personal responsibility that you have to do your homework and take care of those basic things. Filing a statement of economic interest is a basic requirement. Opting in and filing your FCPA requirements is a basic requirement. Those are the 2 most basic things. And so but we want to provide as much information to get them there. And so this shouldn't be hopefully an endurance test, but if y'all have ever run for office, which some of you have, you know that it is an endurance test to some degree, so that comes with it. But I wanted to assure you that we are doing as much as we possibly can to assist and to educate.
I'm not sure, I'm trying to remember when you go to file that you're going to run and you pay your fee, whatever, if there's an opportunity where you sign stating you understand what you're doing, you presented information like that so that you can always go back. Well, when you file to run for that position, you were given information and phone numbers. Is that happening? Is that there?
So some locals, I think, actually do provide that. I don't think Jeff all do. Is that correct?
No.
Yeah. Some do, and I wish, frankly, all did, but we can't make them.
Yeah.
We can recommend, and we recommend often. When we talk with league municipalities, we make recommendations. Once again, I can't make things happen, but I can recommend. When we talk with county commissions, and I met at their conference and spoke at their conference just last month, we make recommendations there. We can't make them do anything, but we can recommend. Many do. Many provide that exact information you're talking about. And I mentioned that Mr. Hall, I wish that they had provided that to his area, because I think they would have benefited from it, because they definitely want to try to do the right thing, but they didn't have that benefit in his local county.
Thank you.
So his record shows then that he was fined $332, and what else?
Well, so he was fined a total of $1,043.22. The Secretary of State's office's recommendation is that you just uphold the first 2 offenses, because there were a total of 10, and this would bring that total fine down to $333.22.
So what's on his record?
It would just be those first 2
What's the first
civil
2?
penalties.
Yes, ma'am.
Yeah.
We don't keep that kind of record like a court.
Like the monthly and one weekly?
Yeah,
Is
that
what
would
it
be
is?
the monthly associated with February 3rd, and then the first weekly report that was due in April 27th.
Gotcha.
And these are civil fines, these are not criminal, so there's no record as you would
Okay.
have in a court.
It just affects, like if you have multiple civil penalties, the fine is higher based on the amount of penalties you have before. And then at a certain point, there is a presumption of intent. And so the Secretary of State's office will automatically refer anything above, or anything for or above, to the Attorney General's office.
The code requires us to do that. So anything that's 4 above, we have to send a notice letter to the local DA in the county for which that candidate resides and to the Attorney General's office. Now, I'm not trying to speak for any DA or any AG's office. However, since I've been here, I've never seen one prosecuted, so I can speak to that. So,
Yeah, but the imposition of the two, or the reducing this to 2 violations, that's consistent with what the board has done the last 2 years?
yes, sir. Yes, sir.
Okay. Any other discussion?
I know we ask the same questions every time.
It's okay.
I think I got it this time. Thank you.
Yes, ma'am.
All right. I have a motion.
So moved.
Okay, that motion is to dismiss the 8 violations, hold the 2 violations, and a fine of $333.22. Is that right?
That's correct.
Okay, all in favor?
The next appeal that we have for you all comes from Chiquita Searles. She is appealing 5 penalties with a total of $150. The Secretary of State's office's recommendation on this one is to uphold the first violation and the fine associated with it, and to dismiss the remainder, and that would reduce this fine down to $10. Is Ms. Searles here today? She writes in her appeal that it was her first time in an election and it's new to her. She had opted into the municipal election, and she has made the necessary corrections to opt in for the general. It says it will never happen again.
If she ever runs again.
Well, she says she will get her reports filed correctly, so I think she's not completely put off.
And as you can see, usually in the municipal races, the amounts are far less than the state or county races. So that's why it's less than this one.
I think what we're seeing, that's new to me in educational, we're seeing a cycle
Yes, sir.
during elections.
Yes, sir.
Is that we as a body have got to do a better job somehow in this election cycle. I would hope we'd go back and review what we did. Is it getting any better? Are the issues still the same? If they're still the same, we're not addressing it properly. If it's getting better, that's good. But communications is so important. It's just unfortunate that everybody doesn't do it the same way. Because I think the candidates need to have that information, particularly if they've never run before. We've had cases where a candidate has used a person before and they didn't know things had changed. But it's just, you know, I would hope that we would learn from the next cycle we go through, that I think it's only fair that candidates have their opportunity. So it's
I would say that someone who has a great history working with league municipalities, as yourself, could probably motivate the league to give good instruction to all the
let me know who to talk to. I'll be glad to contact.
I probably have spoken with them
They may not
already.
give me a microphone either, so I'll be glad to talk to them and bend their ear.
Yes, sir.
All right, any further discussion? Now I have a motion on Business Searles. Okay, and that's for one fine, or excuse me, one violation and a fine of $10.
That's correct.
Okay, all in favor? And any opposed?
The next we have is Clifford Jackson, and he has paid that fine, so that appeal has been withdrawn. And then we have Emily Jones, and she is appealing 5 penalties with a total fine of $2,081.29. The Secretary of State's office's recommendation on this one is to uphold the first violation and dismiss the remainder. Is Ms. Jones here? She writes in her statement that the missed filings were not the result of any intent to disregard the campaign finance requirements. It was just her first campaign and was the result of an inadvertent misunderstanding of the filing requirements and the reporting schedule. Once that issue was identified, she worked to ensure that all the required reports were filed and that her campaign returned to compliance. And again, the Secretary of State's office's recommendation on this one is to uphold the first fine and offense, so that would reduce her fine down from $2,081.29 to $198.69. Mr. Jones, if you have anything further?
And this is consistent, and once again, that's one of our primary goals, to be consistent with how we treat everybody that comes through our office, and that we're fair. And so once you get 4 or greater, then we have historically just asked for 1 violation in that window of numbers of violations, and to be consistent, we make the same request.
Okay, any other discussion? I have a motion on Emily Jones.
Move that we adopt the recommendation.
Okay, so we got Chips with the motion and Joe Smitherman with the second.
Thank you.
For 1 violation and a fine of $198.69.
That's right. The next appeal that we have is from Philip Dembowski. He's appealing 5 penalties with a total fine of $1,675.26. The Secretary of State's office's recommendation again is to uphold just that first fine and offense, which would reduce this fine to $124.13. Is Mr. Dembowski here? He writes in his appeal that he apologizes for the late filings. He's a first-time candidate and was unaware that he had opted into the incorrect reporting calendar within the filing system. And once he realized it, he took steps to ensure future compliance. And again, that recommendation is to reduce the fine down to $124.13.
I'll second it.
Mr. Chair, I don't think y'all actually voted on Emily Jones.
No.
We had a first and a second.
My
and I don't
bad.
think you called for the vote.
We did.
You did? Okay. Y'all did vote? Okay. We didn't hear it. Okay.
Can someone confirm that, though?
I did not hear it back.
Okay. We'll take it back up.
Maybe if y'all bought us some more microphones, you might.
Oh, we're on loan from the Public Service Commission. We're trying to
I got you.
Okay, so we've got a motion by Mr. Pappas and a second by Mr. Pierce on Philip Dembowski to reduce to 1 violation with a fine of $124.13. All in favor?
Aye.
Any opposed? Nay. All right. And we're going to go back to
Emily Jones.
Emily Jones.
The fine on that one was $198.69.
Right. And let's just go ahead and let's get another motion.
I move that we adopt the recommendation.
Thank you. Okay.
Yes.
Gotcha. All right, all in favor, aye.
Aye.
Any opposed, nay.
Okay. The next appeal we have is from Ronald Tracy Adams. He's appealing 4 penalties with a total fine of $675. The Secretary of State's office's recommendation is, again, to uphold just the first fine, dismiss the remainder. So that would reduce his fine down to $200. Is Mr. Adams here today? He writes in his letter, or his filing agent writes, that all of these fines were associated with a single event caused by their lack of experience and understanding of the details, and was the first instance of being forced into a runoff for the primary election, and they did not realize that they were required to opt into a new reporting cycle for that runoff. And again, the Secretary of State's recommendations is that this be reduced to a single offense with a fine of $200.
And do I have a motion?
So moved.
Okay, second. All right, all in favor, aye.
Aye.
And any opposed, nay. All right. Welton Dale Graben.
On this one, hearing an appeal of 4 penalties with a total fine of $900. And the Secretary of State's office's recommendation is again to uphold that first offense and fine. And here this would reduce the fine from $900 to $300. Is Mr. Graven here? He writes in his appeal that he was a first-time user of the reporting system, and he found the website difficult to navigate and misunderstood part of the submission process. He says that all transactions were entered into the system, but he didn't realize that there was an additional steps required to submit the reports. And after discovering the issue, he spoke with the Secretary of State's office, who advised him that reports needed to be filed on a monthly basis. And she assisted in correcting the previous months, but he had some issues that caused some ongoing confusion and difficulty. But he said at no point was there any intention to withhold information or avoid compliance. And again, the recommendation is to reduce it to one offense of $300.
Can they pay these fines out of campaign funds or out of
Yes.
personal
Yes,
funds? Okay.
We have a motion to reduce to 1 violation and a fine of $300. Okay, Greg moves it, second.
Second.
I'm sorry, Judge Sedgwick, did I cut you off?
No, sir.
She and I were chatting.
Who's the second?
Chips.
Sorry, it's hard to distinguish the voices.
All in favor?
Aye.
Any opposed?
The next appeal we have is from Michael Ray Beck. He is appealing 3 penalties for a 3rd, 4th, and 5th offense. The first 2 fines have already been paid. We heard appeals from him previously that were, some of them were set aside and some were upheld. Regardless, the 3 appeals that we have for you today are a total fine of $1,399.12. And the Secretary of State's office's recommendation is that we uphold all of these fines and offenses. Is Mr. Beck here today? He writes in his appeal that he is a first-time candidate, and I am a first-time candidate. Only filed the FCPA when he received an email to file, and he was not told that the weekly reports were due. And again, the Secretary of State's office's recommendation is to uphold all of these. So I'll turn it over to Mike Jones.
So the reason why, and this is once again to be consistent with how we've handled these cases in the past, when we always work with everybody on that first appeal during their election cycle, and we recommend the appeal. And many times you hear us in here recommending that you dismiss them, and so that's our norm. But we only give that shot for one time during the election cycle. If at that point we're doing everything we can to educate and make sure they don't have this happen again. So the responsibility has to shift greater to the candidate after that first appeal. That's our position, and especially when they now know that our analysts will work with them on every one of these, and that's part of what we do. So to be consistent, once we agree to the one appeal and typically we dismiss, if they come back for another appeal, and we tell them this when they have that first appeal, we give them a notice of it, is that we do that one time. We don't do it. We don't make a recommend to dismiss after that. We have to honor the violations on the second go around, or ever how many they come back with. So once again, to be consistent with how we've handled everybody, that's how we handle this case.
Okay. Do I have a motion to reject or overrule the appeal and sustain the 3 violations in the amount of $1,399.12?
I make a motion to approve.
Okay, Greg. Judge Smithman, second. All in favor?
Aye.
Any opposed? Nay.
Thank you. The next appeal that we have is from Katrina Hennings. She is appealing 1 fine and offense. It is the 3rd offense for this election cycle, and the fine is $472.90. And the Secretary of State's office's recommendation is to, again, uphold this offense. Is Ms. Hennings here? Would you like to speak to the commission?
Yes.
Okay, if you would come down, and have you signed in?
She is.
Great. And then before you speak, I just want to let you know that intentional violations of the Fair Campaign Practices Act are criminal in nature. And so if this were to go to a court to be prosecuted, anything that you said to the commission today could be used against you in court. And with that understanding, would you still like to address them?
Yes.
Okay. Then I'll have the court reporter swear you in. And yeah.
Yes, you can go ahead and make this. Raise your right hand. You do solemnly swear to tell the truth, the whole truth, and nothing else but the truth, so help you God? Yes.
Well, no, I'm just going to turn your microphone on.
That's your microphone.
Get more microphone here. I'm gonna bring my own, I'm gonna bring a megaphone.
If you could turn that a little bit closer to you. Now,
Okay, now? Okay. Do I just state, okay. I know it says it's my third offense or whatever you call it, penalty. Again, I can relate to every one of these because this is my first time to run a county election and have to file the reports and things. So the very first time that they approved my appeal was my paper, I never had a number assigned to me because my paperwork had an error on it. So when it came time to file that report, I couldn't file the report because I hadn't been assigned my number. Does that make sense? So in explaining that, they appealed it, and that was great. The second penalty was the night before the runoff election. I was out putting out campaign signs to 2 a.m. and I filed it like 30 minutes late. I was like, oh no, so I paid that penalty because that was clear my fault. This one, and again, I think it's the education of this when you've never ran or never filed these reports. My system, when I pulled it up, it had no reports left after my election. So I just thought I had, to dissolve it and have time to get that in. Well, the office was very nice when I called and realized that I was due a report because they showed me how to go in and generate new reports. I didn't realize that. I guess someone had set it up for me at the beginning, but there was no report showing due in my file. So that's why I didn't file it. It wasn't because I was trying not to file it, if that makes sense. So that's my case. Sorry. And it's all of not knowing. I really think we should, each county, each city should have an orientation on this because I feel like I'm pretty educated, but these reports, not knowing and it being, I just didn't know the routine process, so.
what office did you run for?
County Commission of St. Clair County. Yes.
And
Go ahead.
Was this a runoff election that you were?
Yes.
Okay. And so, one of the things that we do publish, and once again, we do hear, and we do work with everybody, as you indicated when you called in.
They were very helpful.
We do what we can, but one of the things we do, we also post the FCPA filing calendar as like an electronic hard file that you can print or have reference to. We do that for an additional kind of mechanism to give notice that if you are still in the election process, that you would still be due to keep your filings. So once again, in a runoff, you would still do that. The reason why the system does not have an automated continuance from say a primary to a runoff is that the FCPA system does not show who won and lost elections. It doesn't reflect that. All we do, and the whole system is based on voluntary filings, and that's how the system is designed and set up. It's how the legislature wrote the language. So everything's based on that premise. So anytime you have like a new election, for instance, in this case, going from a primary to a runoff, then you would have to let us know that you're in the runoff and then opt in, and that's what happened, is what it sounds like.
Right, but it was the last report after the election was over that I didn't have a form generated, and I didn't realize to go in and generate a whole new
Right.
list of forms.
And so once it converted from primary to runoff, that's when you have to create that opt-in. Just once again, we We do not come out to try to punish people, but we also have to have sort of a standard that we go by, that we treat everybody the same. And so it's never meant, as
Oh, I
you've,
know,
as you've
I
seen, we try to work with it, no matter if they call and no matter what the circumstances, we still work with everybody, because we do have a lot of first-time candidates, and so we go to great length to try to help. But we still have to be consistent, and that's the one thing for us to be fair. If we start isolating and treating every case a little differently, it makes it appear at least unfair to most everybody else, and that is something we do not want to do. So to be fair and to be consistent, we try to apply the same rule to everybody out of fairness, and that's all. In this situation, there was a prior appeal that we probably recommended that you appeal, and it was dismissed. And then I think the second violation, you indicated that you knew exactly what occurred.
30,
And-
just a few minutes late.
And so, and then this was the third. So to be consistent, that is how we've always handled the cases. We're not doing that because we don't want to be the gotcha office, but we also have to be fair, and that's our approach.
Can I just confirm, the runoff is a different thing, so
Correct.
she's correct, when
That's
she
correct.
went into her account, there was nothing there to do.
That's correct.
And then she was responsible for update,
That's
okay.
correct.
So this is a
And I
little bit
didn't
different.
realize it until they notified me, and then I called the office and they explained, and
But
then
this
I
is different
understood,
than the regular
That's
election.
correct. Yes, ma'am.
In the regular course, would a report pop up on her page telling
Correct.
her
If she
that
was
the-
still, if she's still active in her primary campaign before the election date, then yes, as she indicated, it will pop up. Once you opt in, it does give those notices, they're electronic. But once you move to another election cycle, which a runoff is a different election cycle, then you have to re-opt in for it to queue up again. And that's true no matter what level of race or what level of candidacy you're in, whether you're running for governor or whether you're running for county commission. It's the same for everybody.
And what's the amount of the recommended fine?
The fine is, it's set by statute. It's $472.90. It's relying on that. So hang on, let me adjust this actually, because it should be adjusted if it's we set aside the first offense and penalty, and you paid a single fine, right? So
That's correct.
I do need to reduce this somewhat. Just let me do some math here.
And we don't oppose that. We never oppose that, so.
I see a lot of heads being nodded as you were doing your explanation.
While we're doing that,
Yes, sir.
is this you've told us before, is this the first or second year? How many years have y'all been using the computer input system?
So as far as what year did it start, actual, Jeff?
2014 is when it first.
So the original system started in 2014. We did transition, was it last year?
Yes.
To a more modern system that can do this better. And there was a transition period. We were very upfront about that when that was going forward. So we did expect some things, and we adjusted for that. But we've now had that in place for a good while now. So it's been in place that long. It is, and now that municipals are on the same system, it makes everybody uniform, which is good because it treats everybody the same. And frankly, some municipalities were probably a little more vigilant than others back in those times, but now everybody's on the same system. It allows us to treat everybody exactly the same.
While Brian's working on that,
Yes, sir.
fully respect the Secretary of State's goal and practice of
Yes, sir.
treating everybody the same and trying to have a very similar approach. I mean, that's the right way to do it. I think it's exactly the way to do it. I think, or this may be more of a question, but I think we have discretion
Yes, sir, you do.
ourselves in reviewing it.
You do.
Okay.
Yes, sir.
You have complete discretion in how you deal with any appeal, and if you want to treat them differently, you can. And this is obviously a little bit different because this is a runoff election as well in comparison to a regular.
And do we have discretion to reduce the amount of the fine?
You have the discretion to reduce the fine and the offense. You can dismiss all of it if you want to.
No, we can't add to. We can only we can reduce, but we cannot add to the fine.
That's a different question. I don't know that you can't, but if you want me to look that up,
Don't
the
add
legal.
to it.
No, I can look up the legal.
Can't add to it.
What I would say is the commission has discretion to impose fines for failure to find, or failure to file, or timely file, but I don't know
So
the
the code-
parameters of that. We don't do that. Y'all, the commission typically does not do that unless there is an independent action separate from the Secretary of State's appealing it up. So the answer is, I'm not sure if you can raise the fine for this offense independently. But
No, the statute sets a limit, a cap on the amount of the fine, and so the highest that this fine could be is not the $472 and 90 cents that's associated with a third offense. It would be $354 and 68 cents that'd be associated with a second offense. If that makes sense, or if I've just confused things for you. It's based off of a percentage. It's a 10% for a first offense, 15 for a second, and 20 for third and above.
And that's codified. That's
Yes.
not, we don't have the discretion to play with that. So, and we tell that to everybody, we don't have that discretion. You guys have some discretion. We have zero discretion.
So if you all wanted to uphold the fine, I would recommend that it be reduced to $354.68 in accordance with that previous dismissal that we had from the first. But you can reduce it all the way to zero if you all want.
54,
68.
68? Sure.
Prior to running for the county election, I've served 18 years through the municipality, and I've always filed my reports on time, my ethics and all that. This was strictly not realizing how the system worked to generate the new forms after the runoff election.
Question for you, when you signed up to run, were you giving any information, any orientation of any type concerning these questions we're dealing with?
No, I don't want to get my county in
No,
trouble,
I
but no,
think-
sir.
I think that's an issue we have.
Well, and that's what I suggest, and when I talk with them, I think I might have even put that in my letter. I just feel like there should be some additional, apparently it's not just me, so maybe an orientation on, hey, this is how it works, you know, up to this point. And I'm sure like he says, there is a book and there are guidelines, but maybe just offer it. Everyone wouldn't have to come, but I know I would just to learn what to do.
The book is also electronically on our system. We have a candidate resources page that has just a list.
And
of
had I
things.
known that I needed to go in, I mean, yeah, all of that, you probably could sit and read through all of that, but I guess I just didn't realize it. I'm sorry.
You know, we won't see this for 4 years, I would guess. But looking at it, you know, recently passed legislation that all elected officials have to go through training.
Oh, yeah, and that would be good to put it in that.
Add that as part of the training, that city clerks, which are probably tasked, they're the ones you register through, that they go through proper training, may come to your office, whatever, to get training. And pretty much, I think should be a requirement that every city clerk in every municipality offer orientation to, they can do it as a whole group for the whole county, but the clerk or somebody offers orientation to the candidate, where you take advantage of it, that's up to them.
I will say we have, especially when we knew the transition for municipalities was going to occur, we did offer to the league that we'd be happy to come to their conferences and speak on these issues. Once again, I can't make any group do that, but we expected those kind of issues, and so we did make ourselves available. At the same time, we any other groups that call us, whether it be Clerk Association, probate judges, you name it, we do speak at a lot of conferences, and we do address a lot of these kind of questions at those conferences. And so we are very happy to do that. It helps reduce our caseload if we can do that continuously. So a lot of these groups, we're regulars at their events, and we do speak we have topic issues, but we'll also do a Q&A, and then we'll spend about an hour and a half outside of the conference room answering a lot of questions. And so we do that routinely, but some groups just don't take advantage of that as much as others do.
This has been very helpful to me. Personally, I could see reducing this fine potentially down to $50 if the other commissioners.
You make a motion?
I move that we reduce the fine to $50.
Okay, so we one violation with a $50 fine, is that right? Okay, May I have a second? Oh, Trustee Miniman, you said second?
I think I did.
Okay. All in favor, aye.
Aye.
Any opposed, nay. The mistake Ms. Hennings made was she said that she was out the night before election, putting signs out, right? O'clock in the morning, is that what you said?
Yes, sir.
And what you do, my understanding is you take up your own signs the night before election.
We
That
have-
motivates all of your voters to
we
come
have
out and vote
30
for you the next day.
precincts in the county. So I was determined I was gonna move my big signs and have one located at every precinct.
Polling place.
A lot of those are churches and fire departments, so I couldn't put them out ahead of time.
I see.
So I did that with a couple hours sleep and funny just for y'all to have. That morning, real early before the polls, I decided I'd put vote today's out on the big intersections. So I'm on a major highway putting my sign down and I hear a crash and I think, has someone hit my car? And I didn't put it in park and it had ran over the mile marker sign. And I see my car coming at me, so if you could have seen me trying to stop that. So you need sleep before the campaign.
I have a question.
But I
for you.
won, it was worth it.
I have a question for you on signage. I know my city had an ordinance, how far signs have to be out of the roadway, 3 feet out of the roadway. You can't put them on federal city or state highways. Were you told that? You can't put them out on the interstates?
Yes, my only question that we had one city in our county that usually the state highway department will be the one responsible to tell you if you're far enough back or whatever, but the city was controlling it for the state. So I don't know if that's how it works in every city or not, but yeah, like that road that I'm talking about was a state highway and the right of way was like, you'd have to look up on the hill to find it because of the right of way. Yeah, it was all interesting.
There's no
I don't know that I'll do this again, but,
Some city ordinances are more restricted than the state law requirements.
yeah.
So,
But thank you so much.
thank you, ma'am. Yes, ma'am.
Mark Malone, Craig, is it where we are?
Yes, that is the next appeal that we have for you all. He is appealing a total of 5 offenses, although there's only a fine associated with the first one. And that fine is for $256.46. The Secretary of State's office's recommendation is that you uphold the first offense and fine and dismiss the remaining offenses. That's only going to come into play if he has more violations this election cycle. Is Mr. Craig here today? He writes in his appeal, or the person filing on his behalf writes, that there was a miscommunication with the candidate on the expenditure for qualifying fees. He is unopposed and will not be raising money during the campaign. That's all I have from him. Mr. Jones, if you have anything further?
Same thing. This is 5 violations. We, to be consistent, we would recommend the first violation and dismiss all the others.
Okay. We have a motion?
Second.
Did you get that, Cynthia?
Yes, sir.
Okay. All in favor, aye.
Aye.
Any opposed, no.
The next appeal we have for you all is Aristotle Kirkland. He is appealing 4 offenses with a total fine of $330.42. The Secretary of State's recommendation is the same, to uphold just that first offense and fine. That would reduce the fine to $294.09. Is Mr. Kirkland here? He writes in his appeal, or the person on behalf of his campaign, says that the evidence clearly shows that they properly reported the threshold date and opted into a reporting schedule, choosing the option that he was not participating in the primary. The reporting schedule automatically created showed no reports due until June 2nd, and upon learning that the FCPA system had a glitch, the campaign immediately consulted with the Secretary of State's office, who verified the glitch and stated that this was the first time that she was learning of the issue, and that she was helpful and instructed them to instead opt in for the primary participation and then remove the weekly filing requirements that were automatically assigned. I'll turn it over to Secretary of State's office to address that.
Our position is, once again, there's 4 violations. We recommend the first. We're not aware of any glitch. So I'll just leave it there. So.
All right, do we have a motion?
So we're reducing to 294.20, is that correct?
That's correct.
Okay,
Or, sorry, 294.09.
okay.
Okay. All in favor? Any opposed? All right.
Glitches will get you.
The last one that we have before we can address the rest in mass is from Barry Chansey, and I believe there was some discussion about him possibly paying this before.
I just asked. One of our previous cases paid literally moments before y'all started. This one was one that Mr. Chansey had indicated to our office that he was going to pay, and so I just checked. He has not paid yet, so we have to go forward with the appeal.
Okay. So he's appealing. Okay, he's appealing just the first and the 5th violation, so. Okay, that's not going to change any of our math, sorry. He's appealing 2 violations with a total fine of $280.51. The Secretary of State's office's recommendation is to uphold that first violation, and that would be reduce this down to a fine of $152.91. Is Mr. Chansey here? He writes that he apologizes for his violations and that in previous cycles he was up on top of his schedule, but this year he failed with the violations. He said there's no good excuse due to the excellent tools the state provides to candidates. However, he wants to say that he has all of his devices tied to his company firewall and struggled to get access consistently. They set up a computer with more limited security that enabled to get access to the websites that he needed to enter his data, but he did that late and apologizes for being late.
So once again, to be consistent, we just ask to accept the first.
Sure. All right, motion to accept the Secretary of State's recommendation.
So moved. Second.
All in favor? Any opposed? Nay.
Okay, the remainder of the appeals that we have are all appeals where the Secretary of State's office's recommendation is that we dismiss the fine and the offenses associated with them. And so unless there's anything specifically that any of you would like to address, I'd recommend that somebody make a motion to dismiss these en masse. Yeah.
Second.
All in favor? Aye. Any opposed? Nay.
I believe some people here that are part of that mass group,
Okay.
so that, and they may not be aware what y'all just did, so you might want to.
Sure, so I'll just go ahead and read them all out. Or
So
I just would like for them to send a letter, tell us that we have to come down here if they're gonna get this.
We can't make the decision for the commission.
We'll be glad to hear your case and love you. How much money you got in your billfold?
Thank you.
We are not that presumptuous, so we do not. Thank you.
Okay.
members.
Thank you, sir.
Is that a glitch?
We will now go into executive session to discuss matters relating to the character and reputation of certain public officials or employees, as well as matters covered by the Grand Jury Secrecy Act. No matters will be discussed which are outside the scope of the state guidelines permitting meetings in executive session. We expect to reconvene in approximately 1 hour. All recording devices, video and audio must be removed from the room. Anyone secretly recording the executive session will be in violation of the law. Do I have a motion to go in executive session?
So moved.
And a second? Okay, all in favor, aye? Okay, any opposed, nay? All right. can you hear me? Yep. Taking official action on complaints discussed during executive session. And do I have a motion on the first matter, which is case number 2026-0067, is that right? All right, let's take 27 first, since it comes first. And that's,
Dressed up back there.
Greg, you got that one?
Oh, thank you.
Okay.
Roger, you're looking sharp today. I was commenting on your suit back there.
We going to birthday party.
Oh, birthday party, okay. All right.
Mr. Chair, with regards to the complaint that's filed against case number 2026-0027, I move as follows. Based on the evidence as presented to this commission, there exists cause to hold that Wayne Wizenant, council member, town of Reese City, has committed one minor violation of the Alabama Ethics Act. I further move that this case be handled administratively and that it be referred for review and appropriate legal action to the district attorney of the appropriate judicial circuit.
Second.
I second that.
All in favor, aye.
Aye.
Any opposed, say nay. Motion carries.
Mr. Chair, with regard to the complaint as filed against case number 2026-0067, I move as follows. Based on the evidence as presented to this commission, there exists cause to hold that Wade Wizenant, council member, town of Reese City, has committed one minor violation of the Alabama Ethics Act. I further move that this case be handled administratively and be referred for review and appropriate legal action to the district attorney of the appropriate judicial circuit.
Second.
All in favor, aye.
Aye.
Any opposed, nay. Motion carries.
Mr. Chair, with regard to the complaint as filed against case number 2025-0575, I move as follows. Based on the evidence as presented to this commission, there exists cause to hold that Dexter Hinton, Mayor, City of Marion, has committed one minor violation of the Alabama Ethics Act. I further move that this case be handled administratively and that it be referred for review and appropriate legal action to the district attorney for the appropriate judicial circuit.
I second that.
Okay, all in favor, say aye.
Aye.
Any opposed, nay. Motion carries.
Next one. Yep. Mr. Chair, with regards to the complaint is filed against case number 2025-0588, I move as follows. Based on the evidence as presented to this commission, there exists cause to hold that Natalie Simmons, employee, Clark County Schools, has committed one minor violation of the Alabama Ethics Act. I further move that this case be handled administratively and that it be referred for review and appropriate legal action to the district attorney of the appropriate judicial circuit.
Second.
Thank you. All in favor, aye.
Aye.
Any opposed, say nay. Motion carries.
Mr. Chair, with regard to the complaint as filed against case number 2025-0558, I move as follows. Based on the evidence as presented to this commission, there currently exists insufficient facts to hold that the respondent has violated the Alabama Ethics Act. I further move that this case be closed.
Do I have a second?
That me? Second.
All in favor, aye.
Aye.
Any opposed, nay. Motion carries.
Mr. Chair, with regard to the complaint as filed against case number 2025-0598, I move as follows. Based on the evidence as presented to this commission, there exists cause to hold that Damon Hecker, employee, Bruton City Schools, has violated the Alabama Ethics Act. I further move that this case be referred for review and appropriate legal action to the district attorney of the appropriate judicial circuit.
I second that.
All in favor, aye.
Aye.
All opposed, nay. Motion carries.
Mr. Chair, with regard to the complaint as filed against case number 2026-0016, I move as follows. Based on the evidence presented to this commission, there exists cause to hold that Kimberly Bell, council member, Town of Uniontown, has committed one minor violation of the Alabama Ethics Act. I further move that this case be handled administratively and that it referred to for review and appropriate legal action to the district attorney of the appropriate judicial circuit.
Second.
All in favor, say aye.
Aye.
All opposed, nay. Motion carries.
Mr. Chair, with regard to the complaint that's filed against case number 2026-0026, I move as follows. Based on the evidence as presented to this commission, there exists cause to hold that William Lawrence, Mayor, City of Athens, has committed one minor violation of the Alabama Ethics Act. I further move that this case be handled administratively and that it be referred for review and appropriate legal action to the district attorney of the appropriate judicial circuit.
Second.
Okay. All in favor, say aye.
Aye.
Any opposed, nay. Motion carries. Mr. Director, what is the next item for us to consider?
Mr. Chair, you have before you a list of cases which the staff of the Ethics Commission recommends dismissing because there is insufficient evidence supporting the finding of probable cause. This time, I request that you solicit a motion dismissing those in mass. And I understand that Commissioners Smitherman and Pruitt are recusing themselves from this vote.
Yes.
My understanding as well. Correct. Okay. So do I have a motion to dismiss en masse the cases that are listed and provided for us or set out in them?
So moved.
So we'll make Pappas as the movement and Mr. Pierce as the second. All in favor, say aye. Aye. Any opposed, say nay.
Did I say
I misspoke.
And we'll make sure,
I did
we need to
too.
make sure that the record shows that only Pappas
I
and
did.
Dodd.
I didn't hear it. I didn't hear it.
He and I recognized it at the same time.
We just need to make sure that the three of us, that the minutes reflected, that it was only voted on by myself and Mr. Pappas and Mr. Pierce. All right.
All right.
Wait.
Mr. Director, is there any other business for us to consider?
Yes, sir. At this time, you should consider final disposition of administrative resolutions which have previously been approved by either the Attorney General or the appropriate district attorney.
Okay.
Mr. Chairman, on June 4th, 2025, the Alabama Ethics Commission unanimously found Brandon Best, firearms scientist, Department of Forensic Sciences, had committed one minor violation of the Alabama Ethics Act and approved an administrative resolution at the request of the respondent. The commission forwarded the case to the District Attorney of the 8th Judicial Circuit, who approved the administrative resolution on July 3, 2026. Accordingly, I hereby move as follows. An administrative penalty in the amount of $4,500 be ordered by the commission to be paid to the Ethics Commission by cashier's check, money order, or online payment on or before December 2nd, 2026. There is no restitution owing for this minor violation.
Chair's going to second that recommendation. And all in favor, aye.
Aye.
Any opposed, nay. The motion carries. Mr. Director, is there any other business for us to consider?
Yes, sir. The last item for you to consider is we've given you a list of proposed dates for commission meetings in 2027. And if you approve of those dates, I ask that you solicit a motion to approve that.
Okay. And do I have a motion to approve the proposed 2027 commission meeting dates as proposed or submitted to us?
So moved.
Okay. Judge Smitherman is a movement. And Commissioner Pierce is a second. All in favor, aye.
Aye.
Any opposed, nay. We've concluded our official business at this time. Our next meeting will be Wednesday, October 7th, 2026 at 9:30 a.m. And I have a motion to adjourn.
I move.
Second,
I'm telling you.
Pierce.
Y'all all invited to vote aye.
That's his favorite thing.
Pierce.
That's Greg's favorite motion to approve.
That's great.